So, Ms. Gillette, we'd really like to know what
No
we've been
comment.
charged
I've
with.
told you no comment. Do not harass or stop.
Ma'am, I'm asking you questions. I mean, Deputy Love says we've been charged with 22-15 or 21-5922.
Why are you lying about us in court? We don't have that medical stuff.
You
know
disclosed
it.
the medical records,
You
not
disclosed
us.
it yourself, Jill. Is that
That's a
allowed,
pretty
Jill?
serious
You
You
offense.
can
guys
just
should
lie.
not be filming
Why
in a
not?
judicial area.
Oh, I thought it was a
There
court.
are rules
Isn't-
not to
yeah,
film
the
in
court-
judicial
Yeah,
areas.
this is a
We're not in the
constitutional right
We're
that
like
you guys
right
down
outside
here
the
are gonna have to
bathroom.
understand.
I've told you I'd have no comment if you don't stop following
We
me.
can
I
continue
will
to
charge
ask
you with
questions.
stalking.
You're gonna
We
charge
can
us with
continue to ask
stalking.
questions,
You're gonna
Jill.
charge us with
You lied
stalking.
about us in court. We'd like to know why.
Do not comment
No
on
charges
what-
listed, huh? So you're actually investigating us? Are you ever gonna tell us if we're charged, or is this just a criminal trial that happens without any kind of oversight at all? You just rule it yourself? Do you often lie in court? Judging from what we're hearing, it does seem that that's the case. You wanna share it with us? If I give you an upload link, would you share that with us?
You guys have any other questions, but-
I do. I'd like to know about that duck. Did you kidnap a duck, Jill? I hear you kidnapped a duck and threw a fit inside your house when the police came to get it back for the owner. Is that true?
It was a stalking. It's a stalking. You know the stalking statute says that it doesn't apply when you're
Yeah.
asking you about it, you said, "What would charge you with stalking now?"
Flaunting your laws, huh? Don't pull the door on me, you dumb bitch.
Do not call me names.
Don't pull the door on me. You called me a criminal, you dumb bitch. I'll call you whatever I want.
Roll the record now in Jill Gillette versus Philip Michael, is it Hervey? Hervey, case number 24DN17. Counsel state their appearances, please.
May it please the court, Joe Gillette, plaintiff, appears in person.
Your Honor, Lisa Becker appearing on behalf of the respondent, Mr. Ravi, who appears in person.
Permission to remain seated, Your Honor, to remain on the record so the microphones may pick us up.
I'll give that to both counsel. Oftentimes, it's preferable with questioning and so forth from the podium. Clearly, the defendant has counsel. Ms. Gillette, you're aware that you have the right to counsel, correct?
Yes, I'm aware I'm a right to outside counsel.
And you're waiving that right?
Yes, sir.
All right, we are here today for trial on the petition. Record is being made. Is anybody trying to make a record or recording? That is not allowed unless there's been prior authorization through the chief judge. Okay, nobody indicating that's happening. Are there any preliminary matters before we begin with trial?
None from the plaintiff, Your Honor.
Judge, there's a couple of issues. I think Ms. Gillette plans on testifying from the table. I think she should testify from the witness box and without, if she's going to bring electronic things up, like a witness, if a witness brings things up that she's testifying to, I'm allowed to see those things. So I think she should testify from the witness box without her computer and the electronic things. Anything she brings up with her is free game, I think, for counsel to look at. Just like any witness comes up and brings notes or things, going to refer to it, I'm entitled to see those things. So that part, I also have I've asked for the witness exclusion rule, which you have 3 deputy sheriffs were subpoenaed to testify. I think they should be excluded. Dr. Justin Spees is a witness. He should be excluded. That's all I have, Judge.
Are all witnesses present now? No, not a show of hands. I'm
Yes.
asking the parties if all the witnesses are present. So if I give the warning, then any objection by the plaintiff to the sequestration order?
No, Your Honor.
All right. If you have been identified as a witness in this case, once we get started, you're going to be excluded from the courtroom. You'll need to not discuss your testimony with anyone other than the attorneys for the parties. Once you have given your testimony, you'll be released by the court. If for some reason you're not released, I'll advise you of that as well. So we'll do that here in a moment. All right. Ms. Gillette, in regards to testifying, did you have a response?
Oh, well, Judge, when I go to testify, I'll be up there, but all the videos will come in through witnesses.
All right. Well, if there's a witness that has reports, written reports and so forth, they may take those up there. I don't want people just reading from them. But if it refresh their recollection as to dates and so forth, then witnesses can do that. In the event that, I don't know, this doesn't happen very often, if somebody has some sort of electronic device that they're looking at their notes from that becomes a little bit more difficult. So if it can be avoided, I would ask that the witnesses avoid that. But all testimony I'll take from the stand, unless there's some other compelling reason not to.
For the record, Your Honor, I think that defense is just making assumptions of how I'm going to testify.
Well, all right. Now, I have Mr. Baker's entry of appearance to the petition. I did not see an answer. Is that correct, Mr. Baker?
That is true, Judge. We, at the close, we plan on filing a motion to dismiss, but that's correct.
All right. Are there any items that can be stipulated to or at this time in regards to exhibits for either party?
Are you stipulating to the emails coming in?
Yes, I can stipulate to those.
We'll deal with them as they come up then. I just wanted to, if there's things that we can streamline, I would ask that we do that without being prejudicial to the case, of course.
Do you want me to lay those on the evidence table, Your Honor?
I have them. I've got, it's not necessary.
All right. In regards to exhibits, I want them marked as, and if it's a document, a printed version of it, and it can be referred to. If there's copies for counsel of the court, that'd be fine at the time of the exhibit being offered. In inquiry earlier with counsel, it's my understanding there hasn't been an exchange of some of the exhibits. However, both parties are wanting to proceed today. Is that correct?
Yes, Your Honor.
Yes, Your Honor.
Very well. I'll hear, first of all, I'd ask that the witnesses, subpoenaed witnesses, exit the courtroom till you're called in. Please stay close by. Don't want to have to go outside to find witnesses. Thank you.
Sheriff Walker will be my first, Your Honor.
All right. First of all witnesses other than the parties out of the room now. Mr. Baker, your witness is out?
Yes.
Okay, good. All right, I'll hear opening statements at this time, beginning with the plaintiff.
Judge, do you want the stipulated exhibits on the table or handed to you?
When they're actually offered as exhibits, then it'll be presented to the court. I have reviewed the petition, and there were some of these documents I believe were submitted as a part of the petition. So I may have a copy of those, but I do want to be sure that the record's clear as what's admitted. Opening statement, please.
Your Honor, I'll keep my opening statements brief. I filed a petition for protection from stalking against Mr. Aravi. Mr. Aravi has come down to Elk County numerous times. When I'm on the docket with the commission especially, he's come down. He has followed me to my vehicle. He has recorded me live stream on YouTube. I do not access their YouTube stream. I have no care, desire, or want to access their live stream. Under the cases that involve the Phelps, there were several U.S. Supreme Court decision findings that were made in Snyder v. Phelps. One of those is they can put what they want on their media stream, on their own web pages, on what they do. I don't care to go look at it, so that doesn't matter to me. In Snyder v. Phelps, there were lots of hateful things put on social media and websites that affected the father of a fallen soldier. This is not the case. I have filed this based on physical interaction with me, which is one of the events. I have filed this based on him prying into my personal life that is outside my jurisdiction as a prosecutor. There are different levels of scrutiny for elected officials. County attorneys in small local counties are a lot different than, say, President Trump or President Biden. And there's a different level in what is elected officials. And though I am an elected official in 2 small rural counties, I am not a national media person. I am not the president. I'm not the governor. I'm not the attorney general of the state of Kansas. And I have some rights to privacy in my own personal life. It's obvious that he's been trying to pry into my personal life because he's asking me about a duck that went missing in Fredonia, Kansas. So he had obviously gone and tried to obtain information that was about me personally from someone over in Fredonia, because that's not something that would be publicly known. That's not something that's been in the media, and that's not something that anyone would have access to unless they went snooping into my private life. And I have talked about that in my my petition. I, as you know, raise ducks, and I'm a well-known person to care for ducks. In fact, my Parks and Wildlife officers know that if they have a rescue that is a rare or endangered species, I would be able to rehab it. That's not something that's publicly known. But it is something that occurs because of my skills and abilities. As we move into this case, I think it will show that he has continued to message me personally. He has made statements in his emails that hint that he knows that he is passing the line, trying to justify himself, saying, I'm emailing you as an elected official. I get to email you because you're an elected official. I don't have any business with him. There's no reason for him to be following me. There's no reason I should have to wear it to my back every time I leave and come into the courthouse where I'm here to do my job. There's no reason that my family should have to fear. His followers have started making tons of threats against me. Those are his followers and not his actual actions. But his actions have ramped up to the point that he caused physical contact with me. I had prepared the petition after the physical contact, but waited to see if he calmed down, dissipated, had any reason to leave. But the behavior has not. And after every single hearing, he emails me. Anytime he gets a whim, he starts emailing me. And this was filed after the last email, which was October 30th of 2024. It is the continuing desire to have contact with me. As a county attorney, and previously as a guardian ad litem and a defense attorney, I'm trained to keep my composure in a courtroom or wherever I may be to try to stay calm. Although I may appear calm on the outside, that does not always mean that I don't have a fear on the inside. I don't show it the same as other individuals because I'm trained. Attorneys are trained to do that. It doesn't mean that I don't have a fear that they could come over to my town or they could follow me outside of the courthouse further cause problems for my personal life, and there's no reason for this to continue to occur. There's no reason for him to be emailing me. None of it has to do with business. It's just literal rants and craziness. There's no necessary reason for it. The calmer I stay, the more he amps up. They like drama on their YouTube channel and try to make it where it's not. There have been untrue statements about me posted, both by the defendant in the criminal case that he's following and by him by repeating things that that individual has said. So there's no reason for them to be prying into my personal life, following me to my car, causing physical contact with me through the door. And frankly, I don't want him within 30 feet of me, 50 feet of me. I've had to hire private security because I've had numerous followers threaten me. He's now faced physical contact with me. Nothing extra expense that has cost me. And at the jury trial, he ran towards me after I had filed this case and ran up behind me. I don't know if he was hoping my security would tackle him or something more would happen, but he literally approached me during the jury trial after he had noticed this case was pending and ran up behind me. My security is here to testify about that. And so then he didn't move. I moved on to my office, and he had to be removed and nudged out of the way by security because he was standing outside the judge's chambers out here in the hallway. So there's no reason for all of this and for him to be contacting me personally.
Thank you. Mr. Baker?
Thank you, Judge. Judge, the analysis that you have is constrained by KSA 6031A02. And you didn't hear in the opening statement anything about contacting commissioners and this county prosecutor not being a legitimate purpose and not constitutionally protected. That is one of the elements. And in fact, when you see these emails, they're all sent to the commissioners about county business. They're sent to the prosecutor at her official email address, talking about, in fact, she says that he can't even make Cora requests. That somehow that's not a legitimate purpose or constitutionally protected. She says she'll admit she's a public figure. And Kansas, there's a case, Cindy Baker v. John A. Regan. It's not published in 2018. The district court was reversed in that case of bringing a protective order against a parent of a child. And the court said that the parent had a legitimate reason, even though the other parent didn't like it. Now, Kansas doesn't have any case law on public figures. This public figure trying to get a protective order. And there's a reason for that, because you just can't get it. I will cite to you in our motion to dismiss, I'll file after the presentation, they did deal with a public figure. They have an identical statute. In that case, it was a state senator who filed a protective order against a person. Same allegations, I don't like it. And the Florida court said because Petitioner is a public figure and not a private citizen seeking quiet contentment while going about her day-to-day life, the calculus about what constitutes harassment, credible threats, or even defamation against her is different. So that they say, look, the injunction process is not intended for use in punishing mere offensive incivility, which is what she's saying. I don't like the words he uses, or statements that in isolation may appear far more menacing than when considered in their true context. So it's not to silence political opponents. And they go on. Though the words may be based, insulting at times. It's pure political and protected speech, deserving of the broadest possible First Amendment protections. The court there reversed the district court. You're not going to see anything, and this is a citizen journalist, you'll not hear any evidence that what he did was not for a legitimate purpose. These buildings are open to the public. There is no law against videotaping public people in public places. There is no law that says that media cannot be in the hallway or in the courtroom. There is no law that says that just because she doesn't like the media asking her questions, and even if she says no comment, that doesn't mean the media has to stop asking her questions. They don't get a free pass on that. And so you'll not hear any evidence today that says that anything he did was not for a legitimate purpose or for was not constitutionally protected speech. She'll not bring you any evidence today that said he ever physically said the words I threatened to her. Nothing. And she'll conjure up all these things about what others have said. She speculates. She can't pin it on him. She says, well, you gave me bad publicity and others have threatened me. Well, where are they? Why hasn't she sued them? Instead, you'll hear evidence and she just makes it up. And the duck thing you hear, the duck was about a duck that got stolen from a neighbor. She's a public figure. So it is in the public interest to know if the police showed up at your house or the police said, hey, you got to get that duck back to the neighbor. That's something of public interest. That's what the public should know about that. And she can be asked questions about that. She's not immune. So you'll hear all this evidence. You'll not hear anything that meets the elements of this statute today. Thank you.